lifestyle, and notice he's also got, this is 2003, the lifestyle language rather than a sort of identity issue. The petitioner is entitled to respect for their private lives. Their existence cannot be demeaned by the state or their destiny controlled, can't declare their private sexual conduct a crime. However, the case doesn't involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter. So, it clears the way, but does it clear the way? And that's sort of where a lot of the doctrinal puzzling has been ever since. What you get, though, within a few months of the Lawrence v. Texas decision is this, by now, seminal decision of the Massachusetts Supreme Court in a case called Goodrich versus Massachusetts, challenging the exclusion from marriage in Massachusetts. And while doing it ostensibly on the basis of the Massachusetts Constitution, there is no way that this opinion could have been written without the backdrop of Kennedy's opinion in Lawrence. So, does the state have to provide marriage? Here, the Massachusetts court, first of all, characterizes the relationship of marriage in a way that is immediately not sex or gender specific. And which is also something very interesting to watch for in any of these constitutional cases. That is the extent to which what is at stake in these cases is characterized as something narrow and specific, a right of a man and a woman to choose each other as marital partners, marital spouses, or is it a right of individuals to choose the one other person of their choice? Or is it sort of even more abstract and generalized right to participate in those aspects of human existence that are so valued and regarded as kind of fundamental? So, majority here characterizes it in a very broad way. Marriage, a vital social institution, the exclusive commitment of two individuals to each other, nurtures love and mutual support, brings stability to our society. For those who choose to marry and for their children, marriage provides an abundance, legal, financial, and social benefits, and it also imposes all these obligations. Then goes on that when you're barred from this relationship, you are arbitrarily deprived of membership and participation in our community's most rewarding and cherished institutions. That exclusion is incompatible with the Massachusetts principles of respect for individual autonomy and equality under the law. And then almost as an afterthought, we know that this is really a cataclysm. It's kind of couching it as, of course, that our society and our understanding of modern marriage is, to quote Nancy Cott, the historian who was really central in bringing together the social history of marriage that informs this opinion and continues to be central to the subsequent litigation on marriage. These are Nancy's words, basically. Exclusive commitment of two, nurtures love and mutual support, brings stability to our society. There's a reference to children, not a word about procreation, at least not directly here. But then the concept of marriage as capacious enough modern marriage having changed in meaning, not only the end of anti-miscegenation laws, but the profound change in the relationship of husband and wife, spouse to spouse, the end of coverture, the end of official patriarchy, the equalizing of custodial responsibilities for children, the equalizing of spousal support obligations, the equalizing of everything, the coming together of two individuals fully equal on their own footing, their own individuality and autonomy, making a love pact and wanting the world to recognize it. The ability to divorce, and no-fault divorce. When the relationship sours, easy out. A personal commitment can go wrong, out you go. No need to prove that something, the other person wronged you even, just that it's over. Over and over again, the narrative construction of the history of marriage, bought by Massachusetts court, bought later on in California in the marriage cases, resoundingly rejected by the New York Court of Appeals and by other courts that have said, no, the exclusion is justified. But the narrative accepted here is a narrative of this very core, vital social institution that over time, throughout our history, has become more open, more egalitarian, more capacious, so that it's at a point historically and legally where it makes no sense to continue to exclude same-sex couples who are committed to and participating in this narrative of mutual love, commitment, and support, desiring public acknowledgement. It's a story that makes marriage look a lot better than a lot of people would think of it as being. And it's a way, it's a narrative and direction that is aimed both at seeing the opening of marriage to same-sex couples as a conservative move, as a move to contribute to the stability of our society, and use marriage and the marriage relationship, the private aspect of that relationship, as a way to discharge a lot of public responsibilities, basically to get the state off the hook from having to provide child welfare or public assistance and the like, rely on marriage instead. So it's a kind of both this conservative, stabilizing institution, but also the effort to present it as something that is genuinely a basis for individuals fulfilling their dreams, their personhood, their sense of autonomy. So that when this notion gets embedded in Judge Walker's courtroom and in Judge Walker's opinion, without blinking an eyelash, he says that one of the reasons that the state or the Proposition 8 proponents have not come up with a single rational reason for excluding same-sex couples from marriage is that marriage is an institution which is not based on gender differentiation. Marriage has eschewed gender role distinctions. Why? Gender is an artifact of the past. So we're at the water's edge already. It doesn't take very much to welcome in these others. I mean, that's quite an extraordinary move. And, you know, who knows how this will play at higher levels. So then we get we get Gavin Newsom's Valentine's Week game here. I don't know how many of you remember this. This was fun while it lasted. 4,000 people, 4,000 couples got married. All of these marriages are later declared void. Why are they declared void? Because it's a civil disobedience question. The state of California Supreme Court declares that no mayor, no county officer has the right to defy what is the law in our state through an act of civil disobedience by issuing marriage licenses to same-sex couples when the law says he can't do that. So all of these marriages are voided out. A lot of people had a wonderful time, even though it was raining, and they invoked standard civil rights symbol here. But at the same time that they voided all these marriages, the California Supreme Court said, but we will consider this issue of the restriction on marriage to opposite-sex couples on the merits. That is, bring us these cases, and we will consider it on the merits. And that's what happened by 2008, when you get the so-called marriage cases, which for a brief moment recognize in California a fundamental right to marry under the California Constitution, and do so as a combination of equal protection, due process, and more significantly perhaps than anything for the future of litigation and developments here within this state, the California Supreme Court declares that sexual orientation is a suspect classification like race, ethnicity, gender, and religion within California under the California Constitution. Now, one might ask, what's the meaning of that in light of Proposition 8, which then sort of takes marriage away, to put it, carves out? Well, the meaning of that is that in the future, that is a finding that would require any state action that ostensibly limits the participation of gays or lesbians in any aspect of our society to be answerable to the highest standard of review. But most significantly, I think, the marriage cases, and what really does kind of survive, is that the approach of the California Supreme Court very different from a lot of the other states, in that California had substantively already enacted, through expansions of our domestic partnership law, legislation that basically said gay and lesbian couples are functionally equivalent to opposite-sex married couples and are entitled to all the rights and responsibilities of marriage. So that the domestic partnership law, though arguably, and I think sort of second class, separate but unequal, and marriage, not marriage, and all of that, nonetheless says these people are just like all these other folks that get to play within the official marriage world. They are equivalent. So the issue in California was not whether gays and lesbians deserved civil protections of their personal and intimate relationships. The state was already doing that extensively. The issue was whether the exclusion from access to the M word, to the use of the word marriage, whether that itself was constitutional. And the court ends up deciding